Good day to everyone. I'm Praful. Today I'm going to brief you over processing principle, what it is, and how you implement in the practice. Okay, to start with this, we will exercise a sample case in this session. Hope you can see my screen. So this is the sample case study. We have taken the organization www.abc.com, which is established in Europe, and its business is associated with providing training and accrediting certification for the ISO and other information security related domain. To deliver this service, this organization, it collects the PII from the data subject all over the globe, which is required to deliver certification and training to the candidate using the web form and cookie. So in this case, uh, abc.uk, it will provide you with the web form, okay, wherein you have to fill the details. The sample is I have shown what PI it collects. It is email ID, full name, phone number, mail address, etc. And at the same time, whenever the user or data subject it connects to your website, it automatically collects the cookie and the category of cookie which it collects. I have mentioned it as functional, strictly necessary, performance marketing, and advertising. So to start with this exercise, uh, you have to uh, start with the context of organization activity, which is very essential. So in the first phase, you should be able to determine what is the role of the organization, whether it is controller, joint controller, processor, or sub-processor. Second thing is you should be able to identify and classify PI which has been collected, identify and understand the end-to-end PI life cycle, and assess what all global and local regulation are applicable to you. So from the initial assessment, it is evident that UK abc.uk is identified as a controller and by itself is a processor and located in EU region, and hence it meets the GDPR Article 1, that is a territorial scope. Territorial scope is we'll not discussing about the scoping part since it is out of scope of this particular session. Second thing, second finding is it is eligible to global regulation. If you see, since the training is been delivered to India region, California region, and other countries as well. Okay. Coming to the next part, I have also identified that it collects the non-sensitive PII in the form of cookie and through the web form, that is email address, first name, last name, phone number, date of birth, and mail address. I have marked this as a non-sensitive. It is based on the GDPR definition, whether it is non-sensitive PII or PII or normal PII. So now, once we are done with the first step of the assessment, we'll directly pitch in into the next part. That is the agenda that we are going to cover to understand the processing principle. Now, once the scope is identified, the next important thing is the organization should, it is must, it is mandatory to comply with the processing principle uh, that are defined in the GDPR regulation. So GDPR defines 7 principles as listed over here in Article 5. So the I'm listing out what are those principles. So first one is the your processing should comply with lawfulness, fairness, transparency. Second one is purpose limitation. Third one is data minimization. Fourth is accuracy. Fifth is storage limitation. Sixth is integrity and confidentiality. And last one is the accountability. So we'll have a deep insight what this principle means and how we are going to implement in the practice. So going with the more detail into the principles. Okay, so the first principle is it is stating as a consent. So okay, the first principle I'll be breaking into three parts. I'll take it as a lawful as an individual part, fairness as an individual, and transparency. So I'll break this into three different parts. Okay, so for you to process the data, you should be having the legal base. Okay, and that falls under the lawful processing. So there are one, two, three, four, five, six. There are six legal base which organization has to meet. Okay, if it is not met, then you're not supposed to the or not supposed to process the PII. So first we'll understand what is the consent. So whenever we are collecting the data, uh, user or data subject should give his consent. That is, it allows organization to process personal information for the specified purpose. Okay. Next one is the contract. So the processing is necessary to perform the contract, without which, okay, a contract cannot be fulfilled. For example, when you sign in, when you want the email service from the Google, you sign in and you and you're willing to get service. So that is the reason your Google is collecting your email ID, or it allows you to create the email ID. So that falls under the contract, legal obligation. So the processing is necessary for the compliance with the legal obligation. Now here, legal obligation, it uh, implies that after collecting the personal information from you, organization itself is having some responsibility or obligation which it has to further forward it to another organization. The simple example to understand is, uh, your organization is collecting your information, say like Aadhaar card, passport, or whatever finance related, and further it has to share that information to government for the income tax related activity. So, so this also falls under the legal sanction. Next is the vital interest. The processing is necessary to protect vital interest of the data subject. That is in case if you met an accident and there is an emergency and you are not in a position, then hospital can process your personal information for any operation related or for treatment purpose. The the best example is during the COVID, all the countries across the globe, they came up with the uh, application uh, to identify which person is infected by COVID, so that we can keep the distance. Okay, so now moving on to the next one is the public interest. So processing in public interest processing is necessary to perform uh, the task which is carried out in the interest of uh, public. Okay, so most of the government related schemes, okay, for providing you electricity, for providing you other facilities. In that case, if it is collecting your personal information, that it falls under the public interest. The last one is the legitimate interest of the controller. Okay, now here you have to understand, as I said, there are legal sanction. I have highlighted here legal sanctions: a contract, legal obligation, vital interest, and public interest. It falls under the legal sanction. Okay, if your organization processing doesn't fall under this category, then it is mandatory to collect the consent from the data subject or the user. And the consent should be the last option to be considered to uh, process your PII. Now consider the case your processing doesn't fall under. any of the legal sanctioned uh, uh, legally sanctioned purpose, and at the same time, user data subject is also not giving his consent to process your personal information, and still the organization wants to process your PII, then in this case, the organization has to conduct the legitimate interest assessment. Okay, and this legitimate interest assessment, uh, it focus on the fundamental rights of the human and fundamental freedom of the data subject. You have to ensure that these are not overridden. If these are overridden by the interest of the organization, then you are not allowed to process the personal information. I'll come up with the best example to make you make a more clear understanding about this. Suppose an organization they want to monitor your activity by placing the CCTV. Now, in this case, data subject or your employee, they are hesitant. They don't want CCTV. Yeah, they don't want to be monitored by the CCTV in workplace area, which could be the sensitive. So, in this case, your processing purpose doesn't fall under a legal sanction. At the same time, data subject or employee, they are not giving their consent to implement CCTV monitoring. So in the here the organization, it has to mandatorily conduct the fundamental rights and fundamental freedom are not overridden by the purpose. As an employer, I want to ensure that my employee are dedicating their full time towards their work. So this is my interest as an employer, but employee are hesitant. So once the legitimate assessment has been conducted, okay, you have to document this purpose, because when it comes to the regulatory audit and auditor find that you don't have the proper reason to process, and at the same time it is conflicting with the freedom of data subject, then you are eligible to penalty from the GDPR perspective. Hope you understood what is the lawful and the legal base for the processing at minimum. Okay, now we'll come back to our case. In our case, we have identified that uh, abc.uk is collecting cookie and PII through web form. Through web form, it is collecting email ID, full name, phone number, mail address, date of birth, and country. And cookie, it is collecting this type of cookie. So now I have to document this what organization is collecting in the form of the ROPA, and that ROPA is nothing but a record of processing activity, and I have to document it. Now, while conducting this activity, uh, for me to collect all this PII, uh, I have the reason as an employer or as an organization. I have a reason, because without collecting this information, we won't be able to deliver the training and certification, which has to be in the name of a candidate. So that is the purpose. I need to collect all this information. So this justifies, and since I'm using it to deliver service, in our case, the legal base for processing, it falls under the contract as a legal sanction. So it allows me, GDPR allows me to process this particular information. Okay, now moving on to the next topic, that is subsection of LFT. Subsection of LFT, we are done with the lawfulness. Now we'll focus on the fairness and transparency. So what fairness, fair processing says is we have to give the statement to data subject that how we collect the information, how we use it, how we retain it, and where we disclose your PII. And transparency is about how there are certain rights associated with the data subject. Uh, okay, regarding how their information is being processed, they can object, they can restrict all those things. So, as an organization, how I'm going to allow the data subject to practice their rights. Okay, and how I provision this for data subject to exercise their rights. So fair processing and transparency is achieved by implementing the notice. Where in most of the website you can identify there is a specific tab as a notice or a privacy policy. So when you click over there, you'll find the entire detail regarding how your information is collected, how it is used, what uh, how a data subject can exercise their rights. All those information will be given in the notice part. I hope the first part of the principle is very clear. Now we'll move to the second part, that is purpose limitation. Okay. So what purpose limitation says is you need to collect the personal information which is only required for your legitimate interest. So these are the theory part which I have written it over here, and you should either have the legal sanction or you should have the consent. So in our case, we have collected this PII. Okay, now we'll analyze each and everything. Okay, each and every element of the PII collected element is email ID. Here, the email ID and phone number, email ID and phone number is required to communicate to data subject to send the update related to training certification related information. So this is justified. Yes, without having the communication information, how can I send them the training schedule, training language, and once the exam has been conducted, how can I release a certificate? So this is mandatory for me. Now, if I use this email and phone number to advertise that I also we also conduct other training. We also uh, provide you XYZ service. Now the purpose is deviated. Okay, we are initially collecting this information only for the training purpose, and later on we use the email address and phone number to send message that we provide other service as well. So it becomes the new purpose and it becomes the non-compliant. So you have to conduct DPI and RUPA activity if the purpose is new. That is what this point is saying. If your organization want to use email for the advertising purpose, then it should have a legal base, or else data subject must consent it and it should be communicated via notice. In case consent is also not there, then you have to conduct the legitimate interest assessment test. Okay, moving on to the next part. So, as concluded, we need email ID, we need phone number, we need full name. Now, if you look at the other three PI element, that is your mail address, date of birth, and country. Now, date of birth is really required to deliver the training and the service, because the service is for the education purpose. So the child consideration is out of the scope. GDPR has an article related to the processing information about child. So for this, we don't need this. Second thing, mail address. As a service is online, an organization shall be delivering digital copies only. Okay. So we there is no need to have your physical address or mail address. And next element is country. As we are delivering training on a fixed time, and candidate need to adjust as per the organization schedule, and official language use is English. There is no need to collect the where the data subject is from. So we can exclude this. we don't need this particular information. Okay, so this is what the data minimization is all about. Now, moving on to the next part is next principle is the accuracy. Now, the information should be the information which we collected should be accurate. Okay. Now, suppose we'll take the example. I have mentioned the mail address, my physical address as a home address, and I ordered something from abc.com, but I want the delivery to be in office address. So, ABC as an organization, it won't be able to identify it where to deliver. So here, the information should be very accurate for which is required to deliver the service. In our case, we have very little to do with the accuracy as we are relying only on the email. Now, however, data subject should be provisioned to update the email address. That is to shift from the employee ID, employer provided ID to personal email ID. Suppose I registered with abc.com or abc.uk with my official email address. Okay, so all the information related to training would be sent on that employer email ID. But now I switch that organization, my email ID has been blocked. I should be able to get the same information on my personal ID. So organization has to provision them to rectify their personal information. And again, this falls under the data subject. Right. Okay. So now moving on to the next part, that is the storage limitation. Storage limitation is closely aligned with the purpose principle of GDPR. Okay, once the purpose is been achieved, PII must be purged or it shouldn't be processed again. The only processing is allowed when the data is your PII is pseudonymized. Okay, that is unlinking the personal ID. Also, the PII may be stored. There is an exception. Okay, PII can be stored for the archiving purpose in public interest for scientific and historical and for the statistical purpose. Now, in our case, we need to keep the PII for 3 years. That is it is as organization is issuing the certificate which is having the validity for 3 years. So for this historical purpose, uh, we as an organization will maintain the PI for at least 3 years. Now in this case, exception might be applied for other regulation as well, so that care has to be taken. Okay, now coming to the next principle, that is integrity and confidentiality. So GDPR says that once you collect the PI of the individual, you have to ensure that you have implemented the technical measure to protect your to protect the data subject PI. So the uh, we can implement as an organization, it is mandatory for them to implement the technical oriented controls as well as the process oriented controls, uh, which I have listed at a high level over here. We are not going to deep dive into this, and this control can be implemented before collecting or before interaction, during interaction or during processing, and after interaction or after processing. So as of now, this is out of the today's discussion, out of scope of today's discussion. Moving on to the next part is accountability. So whatever we discussed from Article 5.1, okay, we have to reserve this as a document that we have taken all measures uh, from the privacy perspective. Apart from that, there are special obligations mentioned in the GDPR, okay, which are listed over here, designating DPO, uh, taking the conducting the PII, having the record of processing activity. So for controller and processor, different obligations are being clearly mentioned in the GDPR regulation. Okay, so that's it from my side. In next session, we would touching the cookie part and how we manage it in the in practice. Yeah, thank you very much.